Good morning, everybody. By the previous video, we have completed up to Article 167. Articles 153 to Article 167 related to the relationship between the governors and the Council of Ministers of the state. Today, let us discuss Article 168, 169 and 170 relating to assemblies of a state. Of course, state assemblies are part of the state legislatures in terms of Article 168. In terms of Article 168, a state legislature constitutes of the legislative assembly, the legislative council if there is one, and the governor of that state. Though the governor of the state is not an elected member, he is part of the state legislatures by dint of Article 168 of the Constitution. We know governors are appointed by the President of India under warrant, under his hand and seal, under Article 155, and they are removed at the pleasure of the President under Article 156. Governors have to function in accordance with the Constitution as executive power of the state. In case of any ambiguity or doubt, governors are supposed to take guidance from the President of India under Article 160 and act accordingly. We have observed that thus there shall be an assembly and a council in some of the states. The condition is that the membership of a state legislative council shall be 1/3 of the membership of the state assembly, and that the minimum number required to constitute a state council is 40. That means any assembly with 120 seats and more can have a state legislative council if it so desires. It has to be passed by 2/3 majority in the legislative assembly, and the parliament may, by law, form a council for that. At present, only a few states have legislative councils like Telangana, Andhra Pradesh, Karnataka, Madhya Pradesh, Maharashtra, Uttar Pradesh, Bihar, etc. states. In other states, there are no legislative councils. What is use of legislative councils? We will separately discuss when we discuss Article 171. For the present, it is sufficient to know that a state legislature constitutes of the legislative assembly, legislative council, and the governor of that state. Let us come to Article 170. First, I read out the contents of the provision and let us then discuss about it. Article 170 reads, the legislative assembly of each state shall consist of not more than 500 and not less than 60 members chosen by direct election from territorial constituencies in the state. So each state shall have MLA seats ranging from 60 to 500. Indian leaders have misunderstood this provision. I don't know whether they did intently, even knowing. We cannot expect innocence from these constitutional framers. The first and second generation parliament members, the politicians, were mostly involved in drafting of the constitution as members of the Constituent Assembly. At least many of them who are barristers, they must be knowing the purport of each and every article of the Constitution. Or it could have so happened, as is happening in medical field, in the name of specialization, each doctor concentrates only on one particular organ of the body. and he is not concerned or knowledgeable about the other parts of the body. As a result, unless all of them come together and come to a conclusion, there would not be a comprehensive or complete treatment for a patient. The same way, it appears the constitutional framers or the politicians of those days have considered each and every article of the Constitution in isolation with other articles. As a result, the theme of the Constitution, the heart of the Constitution, the scheme of the Constitution got lost. For example, by looking at this Article 170, Clause 1, the then government resorted to bifurcation of the country into states called Reorganization of States in 1956 on linguistic basis. Instead of blaming the then government, I blame even the entire political spectrum and all other constitutional institutions which did not know the purport of this Article 170, Clause 1. The purport is only that you may choose any number between 60 and 500, but that shall be uniform throughout the country. If you see Article 54 regarding the election of the President of India, we know the President of India is elected by all the MLAs in India and members of both houses of the Parliament, excluding, of course, those appointed by the President of India. We know each vote value of MLA is arrived by dividing the total population of that state by the number of assembly seats in that state. That means each MLA's vote value is equivalent to average population of his constituency. It is the population but not voters. It means that each citizen of India, child to old, is deemed to have elected the President of India. That gives him the power to rule this country. We know ministers are appointed people. Sometimes they are nominated members of councils and sometimes not even that for the first 6 months. The total vote value of all the MLAs in India is divided by the number of parliament members. That gives average vote value of each parliament member. For the sake of convenience, each 1000 votes or 1000 population is treated as one vote. That means it is the vote value of each MLA which is the basis of election of the President of India. Article 55 says that each state shall have equal representation in the election of the President of India as far as practicable. If anything is to be deviated from this process, such a bill requires approval of at least 50% of the assemblies in India. So, each population in each state shall be equal, the number of MLAs in the state shall be equal, and the number of parliament members also in each state shall be equal. And the population represented by each MLA should also be, as far as practicable, equal and should be proportionately equal throughout the country. This is the scheme of the Constitution in terms of Article 54, 55, Article 81 and 170. Article 170, Clause 2 reads, each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as practicable, be same throughout the state. It means that each constituency of a state and as a whole throughout the country, the population should, as far as practicable, shall be equal. And the population represented by each MLA also should be equal as far as practicable. I told you, you can refer Article 80, Article 170, 81, Article 170, Article 55. So the population means the population as enumerated according to the latest census. We know census have to be taken every 10 years. The first census were taken in 1951, and based on those census, elections were conducted in 1952. First general elections in India were conducted in 1952 based on the census of 1951. It means that the census shall be taken every 10 years and the states will have to be reorganized every 10 years. And the population in each MLA constituency should also be readjusted every 10 years. This is the purport of Article 55, Article 81 and 170, which Indian administration has failed to understand. As a result, linguistic states were created with unequal population. Some states had merely 60 MLA seats, and some states like Uttar Pradesh had 400 MLA seats. You consider for a while what happens if some states are big and some states are very small. The ruler of this country, according to me, it is the President of India, who is elected by everybody in the country, would give more importance to bigger states and neglects the smaller states, because that is important for him to win his election. At the same time, there should be equality in vote value of each MLA and each MP. If one MLA has vote value of say 1000 and some other MLA has vote value of 100, whom does he president prefers and why? We can understand. So to remove this kind of disparity between members of the legislatures and between each state and the state, the constitution provided that each state shall have equal population, equal number of MLAs and equal number of parliament members, and the population represented by each MLA and each MP shall be, as far as practicable, shall be equal. This is contained in Article 55, 81 and 170. Should there be any deviation from this, such a resolution requires the sanction of at least 50% of the state assemblies in the country. Unfortunately, without understanding this, states have been organized based on language, which in fact is prohibited by the constitution to discriminate people based on community, caste, region, religion, language and sex. The Indian administration did exactly what was prohibited by the constitution, and we are seeing for bifurcation of their country. These agitations for bifurcation of their state are born out of constitutional ignorance. By becoming a smaller state, you lose representation in the parliament. You lose importance in the eyes of the President of India. Without having this constitutional consciousness and with constitutional ignorance, people are demanding for separation of their state, division of their state. These agitators want political positions, and the central government also will encourage without having a constitutional consciousness. They understand that the union or the center should be strong and the state should be weak. To weaken the states, they don't mind bifurcating the states into fragments. Let us see what is happening in Uttar Pradesh. Whichever national party commands majority in Uttar Pradesh is most likely promote somebody from that party as Prime Minister. When a regional party gets majority in Uttar Pradesh, that party will be in such a position as to dictate commands to the union government, either being in the partner of the coalition government or being an outside party. Whereas the smaller states are neglected. Nobody bothers about them. The development of the state will be stymied. We can see clause 3 of Article 117. Upon the completion of each census, when the census should be done every 10 years, the total number of seats in the legislative assembly of each state and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law decide. Please understand Article 173 Clause C says that the state shall be reorganized after every census, and this census should be taken every 10 years. That means after every 2 general elections, there should be reorganization of states and there should be readjustment of seats in the assembly and the parliament. Because there will be migrations from one state to another or from any state to other countries, as a result of which inequalities arise. To avoid this, the constitutional framers foresaw that the state should be reorganized every 10 years. Unfortunately, through 84th and 87th constitutional amendments of 2001 and 2003, it was resolved that it would not be necessary to reorganize the states and to readjust the MLA and MP seats until the census takes place after 2026. When the census will be taken after 2026, the last census was taken in 2001. Thereafter, it would be taken up in 2011, 2021 and 2031. So the next census after 2026 should come in 2031. And that census will be basis for reorganization of the states and readjustments of the seats in assemblies and the parliament. We don't know when those elections come. Recently, we have parliament elections in 2024. So next elections, God forbid, will take place in 2029 and then 2034. So it is in 2034 elections that reorganizations will take place. Until then, this injustice shall continue to affect the states and their people. Unfortunately, we have lost meaning of general elections also. General elections means unified elections for the states and the center every 5 years. Instead, we are dissolving assemblies and Lok Sabha midterm for political expediencies and conducting midterm elections to states and the union at different dates. As a result, it appears to me that India has acquired independence only to conduct elections. Elections are like festivals in India for the leaders, for the cadre and the people as well. People get some employment as political workers and voters will get something in return to their votes, and leaders would be able to collect as much funds as possible, and the bigger leaders have possibility of becoming prime ministers, chief ministers or other ministers or any other political post. So elections are like festivals in India. People want that they should happen every year or every 6 months, but the constitutional intent is not that. General elections have to be conducted uniformly to the states and the center every 5 years, and after every 2 general elections there should be reorganization of states and readjustment of seats, having duly conducted the census every 2 years. Unfortunately, the whole country has gone on a wrong track. I urge the intelligentsia of this country, the press and legal fraternity and politicians to understand what is democracy and what is contained in the Constitution. Everybody praises the Constitution, everybody praises Dr. Ambedkar, and finally does exactly opposite to what has been stated in the Constitution and exactly opposite to the ideals of Dr. Ambedkar. There is a misinformation spread in India that Ambedkar has kept reservations to certain castes to the exclusion of some others, but that is not the truth. The other truth is that Ambedkar has stoutly opposed to add socialist, secular and federal into the preamble of this constitution. Unfortunately, we are running the country exactly in socialist, secular and federal way. This is not the way to respect Ambedkar or to respect Indian Constitution. Thank you for watching my video. I request you to please subscribe, share and comment on my videos. I will be glad to reply to your worthy comments. I have informed several times in my previous videos the purpose of my starting this web series is to bring to the notice of the citizens the constitutional, contemporary and conflicting provisions which Indians have misunderstood, misused, misapplied, as a result of which India is suffering political instability, political uncertainty, political immorality in the form of horse trading, abnormal poverty and strife between castes, communities, creeds, regions and religions. To put an end to all this turmoil, we need to understand the Constitution. The Constitution prescribed a sovereign democratic republic. Republic means a country which is ruled by an elected or nominated president instead of a monarch in which people are supreme. Exactly according to this definition of republic, the whole Constitution was written regarding the election of the President of India, his oath of office, and his duties, discretions, and responsibilities. Unfortunately, we have ignored all of them. Thank you. Thank you for watching my video.